Thank you all for coming to our panel. I know that we have a harsh competition and a lot of interesting panels, and also we're reaching the end of the day. But I was already quite thankful that we weren't the last panel of the day. Okay, so I will first introduce myself. I'm Alexandra Giannopoulou. I am a legal officer and project coordinator at the Digital Freedom Fund, and I'm also a research fellow at the Institute for Information Law, EVIR, at the University of Amsterdam. I am joined here by mainly wonderful people, some in person and some online. You'll see them on stage soon. We're here to talk about open data commons and their relationship to AI. The way that this panel will unfold is the following. I will first do a small introduction to the topic and then give the floor to each of our panelists, and then we'll save quite ample time for your questions and discussion. So first, I would like to introduce all the panelists. I introduce myself, then I will go to Ramya Chandasekar, who is a researcher at the Center for Internet Society at the CNRS, and also thanking Ramya for her invitation to moderate this panel. Yaniv Ben-Amou, Associate Professor in Digital Law at the University of Geneva, and also a practicing attorney at law. And online, I don't know if you can see them, but you cannot see them yet. So we have Mélanie Dulon-Desronay, who is a director at the Center of Internet Society and a permanent researcher at the CNRS, and also Renata Villa, who is, among many other things, also the CEO of the Open Knowledge Foundation. I will start with a small introduction, hoping that our panelists are online. Okay, great. So I wanted to start with a small anecdote from 2019, when I was still a full-time researcher at the Institute for Information Law. There was a story that broke out in also mainstream media around Flickr and big database that was co-opted, used for AI facial recognition. So I wanted to start with this anecdote, essentially, to give you a bit of a summary. A researcher put on the spotlight this data set called Megaface. This is a data set that was created by a lot of research institutions and companies as a subset of a bigger data set. It included 3 million Creative Commons licensed pictures that were all from Flickr. And this data set were used to train facial recognition algorithms, and the way that this story was reported on the media was, well, failure of the open license, the open licenses to predict or account for this problem. I'm not very opposed to this framing. This is quite true, and this is why we're here now, to discuss how do we move forward from this, and how do we bring a balance to what used to be, or at least 20 years ago, discourse on commons and digital commons, and now what happens now. A very small introduction to commons in general. So when we think of commons, even outside of data commons specifically that we're going to talk about today, we are thinking essentially of a method to govern resources, right? This method includes not only legal tools, but socio-cultural, economic, institutional responses, and in the original, let's say, understanding of the commons, the common property regimes, a very well-guarded community, right? So something that from the outside appears as quite open is governed by very specific rules and sophisticated internal systems of accountability. The way that this was reported further in the future, when we started to unravel digital commons, it was mostly, let's say, the second part of what I introduced, essentially the openness, right? So the key feature of what we're talking about for digital commons was access. How do we ensure access for everyone? This is where the legal licenses came to be, and this is how let's say the usefulness of these licenses became apparent. What we realize now is that, well, while we predicted access to be the main impediment to creating digital commons, this is no longer the case. Now we're talking about data governance, we're talking about infrastructures, and we're talking about, let's say, equal access to capture of value or control over who captures this value and when. This is what we're going to be talking about today, legal ways and other approaches to bringing a solution to how do we move forward with data commoning. So I would like to first give the floor to Ramya to tell us a little bit about the law.
Hi everyone, thank you to my panelists for being part of this, and thank you for CPDP for giving us this opportunity to have this panel. What I briefly wanted to speak about in my short intervention was one, on the role of publicly available data to AI system development and deployment, and two, the role of the law, specifically public law, when it comes to the kinds of interests and legal claims involved in the reuse of publicly available data. So first, to start off with, many AI applications, including in particular generative AI applications, are developed, trained on, and require access to and reuse of large amounts of publicly available data to be able to exist and also to sustain their claims of accuracy, for instance, that they are trained on such widely representative data sets that they generate accurate outputs, for instance. What do we mean then by this publicly available data? It comprises of many sources, and one of the biggest sources of that publicly available data is open data, either open government data or data that's otherwise been made open voluntarily by other actors, like the Flickr database that Alexander was mentioning, made open for reuse through the use of certain licenses, like Creative Commons licenses. Other kinds of publicly available data are data that exist on websites that are public to access, which are often reused through web scraping technologies, for instance. And given that there is this new kind of, and at a scale that we never comprehended, this vast reuse of publicly available data for AI, there's a need then to understand more carefully what are the different interests and legal claims in the individual data elements that constitute publicly available data, and also what are the risks and the harms that emerge from reuse of this data in the context of AI. Of course, one of the kind of legal risks in publicly available data, and something that we're seeing a lot of litigation in the US and UK, is copyright. So the fact that artists have put out their content on the web, not for reuse by AI, but to sustain the public domain through Creative Commons licenses. All of this is now being reused by generative AI to create outputs eerily similar to the artist's creations themselves. And so this has resulted in a lot of copyright litigation, for instance. The other aspect is that simply because data is publicly available, or that even if it is open government data, it does not mean that it contains absolutely no personal data. The inclusion of a large amount of dynamic data, sensor data, for instance, in open government data, comes with it a new kind of privacy risk on account of sensors inferring or observing, or analytical tools being applied to sensor data to infer or observe personal data, means that there is now an emerging privacy risk that comes with publicly available data. The regulatory framework, however, specifically in the EU context, is kind of divided in this issue. You have, on the one hand, from the 1990, an emerging set of regulations for open data. It started in 1990 with the guidelines for the cooperation between the private and the public sector. It went on to the reuse of public sector information directives in 2003, amended in 2013. Now we have the new directive in 2019. And each of these kind of regulatory frameworks, they originally started with the release of public sector data for citizens to access, to reuse, to hold governments accountable, to encourage transparency. But an underlying theme from the 1990s has also always been the reuse and exploitation of open government data by the private sector. So from the 1990s, we can see a narrative of data, troves of data held by public sector bodies that are unexploited, that can be exploited in the creation of data-driven services and products. And today we are seeing that exploitation through the development of AI products. In parallel, you had sector or rather thematic specific regulations like the copyright directive, like the GDPR that focus on addressing specific claims in data, like either a copyright claim or in Europe a sui generis claim or a personal data interest in data. And then in 2020, with the EU data strategy, you now see a shift in the regulatory focus. Of course, the data strategy recognizes that there is social value of data. It recognizes the importance of transparency and accountability of both public sector and private sector. But what is explicitly made clear by the EU data strategy is the economic value of data, the fact that data is now a new factor of production. Data is a new form of capital, as scholars like Jathan Sadowski have argued. Data is also a commodity, and it's contributing to the commodification of digital society. And the EU data strategy then, under the ambit of European digital sovereignty, seeks to make data circulate within the EU so that economic value out of it can be realized within the EU, and this value can then circulate within the EU. So ultimately then, there is a hyper-focus on this economic value of data, often at the cost of recognizing the social value of data that stems from the ways in which data is a relational resource, not just a naturally occurring resource or a resource up for exploitation like oil, a metaphor that's been debunked quite a bit. And so what I briefly wanted to say then is that while the economic value of data is important, it's not enough for regulatory focus to be oriented towards just the economic value of data. Instead, as an emerging scholarship that's coming from this field of data commons tries to argue, we can conceptualize data differently. Data is not just a club good, for instance, nor is it just pure data in itself a common property resource, but we can think of data itself more ecosystemically. And what this means then is that we need to think of data together with infrastructures for the realization and extraction of value from data, computational infrastructures, social infrastructures, legal infrastructures, and also then the social relations that are created by digital data or affected through digital data collectively as a common pool resource. This then allows us to think of data governance more broadly, not just as another form of resource management, but as a political vision to strengthen individual and collective rights. This also then, this framing, I argue, allows us to pivot away from a purely global north construction of property or property-like rights to data, to think about other ways in which we can think of shared governance of data. And so here then, this panel tries to bring together different perspectives to think about how we can extend commons-based governance principles, or originally conceptualized by Elinor Ostrom in the context of certain natural commons, then subsequently extended to knowledge commons, and whether we can apply this to the governance of data. And I'll conclude briefly here by saying that there are, of course, ways in which we have to operationalize these governance principles for the collective and shared management of data that protects against its capture and its enclosure by actors such as the state or by private sector actors through the exercise of infrastructural control. But also that if we think about this from a regulatory perspective, a commons-based orientation asks us to think more critically about the role of the state itself. The state is no longer just a sanctioning authority or an enforcing authority to enforce certain rightful or wrongful actions with regard to data, but also that the state is itself a consumer of data-driven services, evidenced by the swift uptake of AI in public services and public management. The state is also a curator of data sets, evidenced by the fact that open government data sets, for instance, are being reused for the development of AI, and that the state plays many multifaceted roles if we adopt this ecosystemic perspective to AI. And so regulatory efforts then need to be tuned in towards these multifaceted roles that the state plays, and this is where I think we can push the regulatory frameworks that are emerging from the EU data strategy a little bit more, to give them more teeth to realize not just the economic value, but the social value of data. Thank you.
Thank you, Ramya. So first we will just go over all speakers and then we'll take questions, if that's okay with you all. Our next speaker is Mélanie Dulon-Deronet, online. Before or while Mélanie connects, I wanted to also mention a wonderful paper that Mélanie and Yaniv published, and it's called Open Data Commons Licenses, Licensing Personal and Non-Personal Data Supporting the Commons and Privacy. You can find it online, and I don't know, has it been published to a journal that I didn't, okay. Oh, not yet. Okay, well, you can find it online. And it's on SSRN. It's a very interesting paper, and it's part of what we will be discussing here. And Mélanie, the floor is yours.
Thank you very much. Hello, everybody. Can you hear me and see the slides?
Yes.
Yes.
Excellent. So thank you very much, Alexandra and Ramya, for the wonderful introduction, and Renata and Yaniv for being with us on this panel. So following the introduction and the demonstration of the policy challenges, it was the proof that there was a need to update existing open licensing schemes to cover all kinds of data, including AI input data, because existing open licenses address mostly copyright, and the risk was by then the enclosure of the public domain. So what we want to address now is the harms and the risks which are generated, which are related to the generation and the reuse of data, and they relate to data protection, but they also relate to the extraction of value without sharing the benefits with the communities. And there are also challenges related to sustainability, financial, but also ecological. So that's why in the paper Alexandra just mentioned, which is on SSRN and soon in an excellent journal, proposes a template for open data commons licensing. So we're developing a set of tools which will support data commons and all kinds of data, like Ramya explained, with the example of data from captors. They also can embed personal data. Also, we want to tackle what was one of the main challenges of open licensing, and this is interoperability. So among like-minded licensing systems, so we want data sets which are licensed under like-minded licenses to be interoperable, and also that privacy is respected, and that so there is this systemic and sustainability of communities who are at the sources of this data commons. So for that, the proposal is to actually restrict the definition of openness for the purpose of the protection, the preservation of both the commons and privacy. So what we embed in the licensing scheme is a privacy pledge, so that licensor and licensees commit to a certain standards relating to the protection of personal data. Also, we set conditions related to the kind of uses and users which will be authorized, all for the sake of the protection of the commons. And finally, in our licensing ecosystem, and this will be presented by Yaniv, there is a need of collective governance, like in all digital commons, and it will also help to ensure interoperability and to have solid political definitions in order to have so compatibility and really define what are the authorized users and uses which fulfill the wishes and the need of the community. So, like Creative Commons licenses, we will have definitions and standard clauses together with some compulsory elements and some optional elements. So, following the needs of the communities. So here you have some examples. So, for instance, the third condition is related to the scope of confidentiality between anonymity and complete visibility. And then condition 5, there will be the opportunity to restrict to some communities only, or authorized only users which respect the same values, and also the possibility to pool financial resources to support the commons and their sustainability. And then, as I mentioned, the privacy pledge, the right to erasure, and a share alike, so that the value are following. So for the next step of these licenses, it's a partnership, so academic and civil society partnership with the Open Knowledge Foundation, and Renata will describe the steps until completion. And there is also so the definition of data trust infrastructure. So following the principles of collective management organization, which is the topic of Yaniv. So these are our two next speakers. Thank you very much.
Thank you, Melanie, and thank you also for the pass to Yaniv. The floor is yours.
Yes, thank you. Hi, everyone. Hi, the remote participants. Just to explain also why we published this paper, to explain the starting point of this. When I was studying the data sharing contractual mechanism, I was surprised to what extent there are multiple rights and actors involved, in particular in the digital ecosystem. Think of autonomous vehicles, think of Flickr metadata, all the underlying metadata of any image that contains so many different data points, which can be subject to so many different legal regimes, from copyright to technical data and personal data. So that's one observation. The second observation, I was also interested to observe that the current logic is that the providers impose their license terms via terms and conditions, and not the opposite. Finally, the data subjects of personal data or a copyright owner on his image is actually the licensor. But they finally never license their own assets. They let imposed the providers providing their terms. So we suggested in this paper to reverse the current logic of contracts and not to let providers impose their terms, but the opposite, the data subjects or the copyright owners and whoever produces data setting their own terms. And therefore, we suggested this legal framework with a large legal contractual scheme that includes not only copyright data, but also any types of data, including personal data, so as to ensure that the contractual framework can capture all kinds of data, multiple actors and multiple types of data. That's just to say the starting point. Now that we suggested this framework, the imperative mechanism that needs to be combined with the contract is to find collective governance mechanism that ensure the effectiveness, the enforceability of such contract. And we thought it would be important to combine this contract with a data trust, or whichever you want to mention or have the terminology. It's anyway an intermediary that may enforce and leverage this contract towards providers. So I will briefly mention the data intermediaries, in particular the collective management organizations coming from copyright, as a blueprint to design intermediaries for this type of collective mechanism. And two, briefly, the benefits and the challenges. And among the challenges, you will see, I will very quickly come to the scalability problem. And we know that we speak about privacy resignation, like no one or many data subjects do not care about their data. So how to ensure that data subjects would choose such as a contractual framework, I think that's the major challenge. So briefly about the blueprint inspired by a collective management organization inspired by copyright. I observed that copyright has a very long-standing experience in dealing and managing copyrighted data from third parties, from artists. So I thought it would be interesting to get inspired by the CMOs, Collective Management Organization, as a blueprint to design intermediaries for the 5 following reasons at least. One reason is that the CMOs in copyright, they follow a co-regulatory approach because there is a state intervention, at least a kind of surveillance, a state approval at certain stage that can monitor at least the work of the CMOs. And obviously you may think of also the EU trusted data intermediaries based on the new Data Governance Act that has either commercial intermediaries under supervision or also a data altruism organization. And this is also a co-regulatory model. And we were checking there are only 1 data altruism organization registered so far in Spain and 2 commercial intermediaries, but definitely this could be an interesting path to develop, and again, inspired by CMO. So first reason, co-regulatory approach. Second reason, that's probably the most important one, is because of their similarities of CMOs and data trust, as we understand that for personal data. CMO, for copyright, they are mostly non-profit organizations. They are created by right holders themselves, and they administrate copyright and monitor usages with accessibility and equal treatment, with the principles of open door, equal vote principle of all members. There is also an appropriate participation in the society decisions, and also a clear data transfer from the data subject to the trustee, to the CMO. And I think these exactly similarities, these exactly characteristics of CMOs are actually what we look for with the data trust or data intermediaries. And by the way, this is also based on many pilot projects such as smart cities or different projects like from Open Data Institute. They also identify these different factors as success factors for data intermediaries. Third reason, because also of the similarity to the managed resource. Similarity because both data, personal data or copyrighted works, they are both subject to an absolute subjective right, and their owners, so the copyright owners or the data subjects of personal data, can delegate their power to manage their data via the data trust. And interestingly, you can also delegate many powers to the data trust, including the power to make access requests, for instance. And you can also collectively ask a data intermediaries, and many data subjects together can delegate many powers in order to leverage their power towards providers. And as a footnote, we are doing that at my University of Geneva with my students. Many students of mine, they ask other students to grant the power, like via power of attorney or proxy, in order to make access requests on the name and of behalf of the other students. And you get, thanks to this system of domino, a lot of power in order to make major, massive access requests and grant a lot of power. And echoing that, I'm working also with a colleague in an NGO in Geneva who is doing that with Uber drivers. So the Uber drivers in Switzerland, they collectively granted the power to the NGO, and they made major, massive access requests, and then they can retrieve the data, they can analyze the data, and potentially leverage and ask a new contract for the data. The fourth reason, it's because of the similarity between copyrighted data and personal data in the massification of use. I don't know if there are copyright or IP experts in the room, but you may remember that CMOs have been implemented in order to face the massification of the use of copyrighted works. In the past, where artists realized that their works were played in different rooms, in different venues, and now with digital, of course, it's even more significant. So with data-intensive industry for personal data, it's so similar to the copyright industry that faced the massification of use, and therefore we had to lead to CMOs. I think this is also a good reason to get inspired and to definitely and finally implement data trust. Fifth and last reason, it's also because of the long-standing experience of the CMO, including when they represent non-trusted owners. And you have heard about the extended collective licenses, for instance, for orphan works, i.e. works whose we do not know who is the authors, or we cannot join the authors. And there are more and more contractual schemes for CMOs in copyright that represent also non-represented copyright owners. And I will come now to the scalability question. Please bear in mind this question of non-represented owners for copyright, which could also be an inspiration for data trust. So briefly, don't rush. So I will now, 2 more minutes to comment the benefits and, thanks, to comment briefly the benefit and challenges of these data trust mechanisms. So as a reminder, so the idea would be personal data subjects would delegate their power, for instance, power of attorney, of proxy, to the data trust to manage their data and exercise their self-determination right through their membership, through their data trust. And data subjects would choose the different data trusts like a political party depending on the values defended by the data trust. So that's just to mention as an outset. So the benefits of this is that this can allow the management of complex data sets. It has been mentioned previously, the compatibility versus incompatibility issue. And thanks to data trust, they may bring more interoperability. Also, they may bring more values. Depending on the data trust a data subject may choose, they may choose that based on values. It would increase data sharing while improving trust and control over the data, because remember, I mentioned to reverse the contractual current logic. It's not the providers which would impose the terms. inversely, it would be the data subjects via the data trust that impose the contractual scheme and the values. And finally, this would correct the power and information asymmetry, because instead of a data subject which does not understand the terms, for which it's complicated to understand under which conditions they delegate their data, they would do that via a data trust with complex and sophisticated knowledge and also some specific values. So this is just to briefly recap the benefits, but of course this comes with a lot of challenges, and that's why we are here, and I would love to hear your thoughts. But among the challenges, there is obviously the question of feasibility, right? Or adoption of data subjects towards data trust, and finally scalability. How do we ensure that the data trust have enough data subjects representative, enough data in order to make also power symmetry towards providers, and finally impose our or other open licensing models. So how to achieve this scalability or feasibility issues? First, of course, and by the way, excuse me, I wanted to say to tackle the challenge, I think it's a mix between bottom-up approach and top-down approach. I'll explain. First, solution, and they shall be all combined together. We shall set up, create data trust, potentially per sector and per community with similar values. Think of online music platforms, for instance, I don't know, Spotify user data. They have potentially different values as opposed to other social media data or other urban data for smart cities, which all of them have different values. So potentially we shall create and set up data trust or data intermediaries per sector and community. 2, for data already collected, data subjects could exercise their access requests via the data trust. And remember, I said, at least thanks to privacy laws, you can delegate a lot of power via proxy and power of attorney to the data trust, and you can massively grant the power of attorney at least to make access requests. And with this second option, the data trust could, for all the data already collected, exercise collectively, massively access requests and retrieve all the data already collected, and potentially ask then the providers to re-license them under new licensing schemes. As I mentioned before, we have some ongoing projects with our students or with Uber drivers who are collecting massively their data, and now they are analyzing their data, and potentially we can rebring this data under new licensing schemes. 3, for data not already collected, and thanks to the setting up of sector-wide data trust, for instance, social media, music platforms, urban data for smart cities, the data trust would have already some power, some representation of a lot of data subjects, and could leverage their open licensing models, being our model or other open licensing models and terms, so that I think, or we think, platforms could at the end voluntarily adhere to such terms as well. Finally, last but not least, I think an interesting model could be also to get inspired by these extended collective licenses I mentioned, known in copyright, where CMO can represent also copyright owners who are not formally represented in the CMO, for instance, for orphan works, and this could also address the privacy resignation or the privacy paradox, because many data subjects would not be concerned about their privacy or the consent fatigue. I know it could be a kind of maybe data patria and matria, I don't know how to call that. It could be also seen as why should someone else care of my data? But it's still an interesting debate, I think, these extended collective licenses that could potentially be also addressed by the data trust and hence represent non-represented data subjects, but potentially it's subject to debate. So I think I stop here because I have also many other things I could say, but I look forward to the discussion.
Thank you, Yaniv. Yeah. for this kind of more elaborate explanation of your vision. I feel the need to also just add to what you said, because you focused on, essentially mandating data access, right? And I mean, I don't see him in the room, but we've written also with Jeff Auslaws, who is, access rights, whoever thinks of access rights, thinks of Jeff. And yeah, we've written an article in International Data Privacy Law on mandatability of data rights exercises. And if you want to get a more deeply legal understanding of what is a mandate, that is where you might find some inspiration. And with this, our last speaker to present also the view and vision of the Open Knowledge Foundation online, Renata Villa.
Thank you for having me today. I'm sorry to be remote. I hope to be with you next year. What I want just to remind is this journey at Open Knowledge Foundation. We have been 20 years trying to address this problem, and we have seen it as a problem, as an evolving problem over time. And I will say that we move from a moment of unawareness to a moment of awareness. In the beginning, when we started working with the Open Data Commons, it was basically the parting point from scratch. People didn't even know what metadata was. It was a training journey of explaining digital 20 years ago. And then today we have a very different public, a very aware public that sometimes goes into extreme approaches of I don't want you to take any of my data, and please abstain to collect any of my data. Or in that sense, let's say moving backwards from a position of opening up and sharing, unconditional sharing. There was of early enthusiasm and maybe unawareness of the effects of this unconditional sharing, to a position of I do not want you to collect anything. I don't want to share anything to anyone. I do not have the tools, I do not have the options that will enable me to open some of the data to some of the users that I will feel happy with. So basically, and then the other thing the other big shift or change that we are witnessing is a shift or change in power, of course. We saw an Open Future and other authors elaborating very well this extreme openness and sharing it all led to an unprecedented concentration of power by some corporations, and also left somehow the public sector a little bit empty-handed, and without the leverage opening up everything, and without focusing on sustainability, focusing on different types of data, we have seen at the Open Knowledge Foundation how states have deprioritized open data initiatives, for example, or the efforts and the investment, early investment that they did in producing data sets, curating data sets, and opening that up. It has been a reduced enthusiasm because there's not a clear gain in doing that. So what we want to do is, with this process, is a little bit like the bottom-up approach that Janine was referring to, of listening to the communities, listening to the needs of the communities, and trying to craft a legal tool, but also a technical tool that will answer the needs and answer the questions and address the concerns of all the communities involved. For example, one of the things that we are dealing with daily in our job at Open Knowledge Foundation, we provide a big chunk of what we provide is the infrastructure to open data, the technical infrastructure to open data. And we are working, for example, with organizations dealing with refugee data, or dealing with sensitive data at the internal of the organization, they want open for them, but they will only like to share a tiny fraction of that to the outside world. So the licenses that exist now and the way to incorporate that license in an automatic way, they're still full of frictions. Something that is also important to remember, and it's a little bit more referred to the previous point, is all the legal transformations, especially in Europe, in the last 10 years. Many of the licenses that we have today were crafted and discussed in a very different world. And all the legislation that took place after is not addressed by the previous legal instruments. So, and in a continent. And so to have a resilient and truly interoperable license, we need to look and actually look at also beyond Europe, all the legal developments that have been out there, and the sophisticated gain of rights that we had in the past decade to incorporate that in this legal instrument. And the last point, and I think that it is something very important for the Open Knowledge Foundation, is that in this extreme, between these extremes of no sharing at all and open to all, what the promise of this new license is to have a tool to convince those who hold the data that is critical to share. If we look at a critical area, for example, the climate crisis, there's many data owned by foundations or corporations that is not being shared at all. And one of the reasons that is not being shared at all is the fear of exploitation, the fear of yet another extractivism process. And there's many legitimate concerns from the communities that hold this data, or the communities which are with a lot of effort producing these data sets. There are a lot of reluctance in sharing that. We have seen it, for example, in our network. Our network is growing now in different countries in the global south, and it is a legitimate concern of this mentality of open it all and share it all is not addressing a dynamic of power that we have seen, a pattern of extraction and a dynamic of power that we have seen in our country. So we hope that in the next phase of the discussion of this legal tool, we will go beyond just discussing GDPR and discussing, the legal technicalities of that this license set of licenses want to address, but to answer the legal concerns and the political concerns and the social concerns that these communities might have. So basically, the next phase will be will cover 4 dimensions. One is technical, because as technology had evolved, we hope to provide an online, ready to be incorporated in apps, adapted in online interactions, in on-app interactions, set of licenses that it is to reduce to the minimum the cost for a company or for a government to incorporate these licenses as part of their code, as part of their apps. The second is a community seal of approval. We want to conduct a series of consultations that will cover as many communities as possible, and not only go broad in the number of countries that we want to consult with, but also in the number of specific communities that we want to consult with. For example, the health community, cooperatives, educators, open data communities, government communities, city communities, to see if these licenses will adapt to their uses. And the next level that we want is also a process of literacy. remind people that actually of the rights, and remind of the changes on the rights that have been how can we offer a gold standard, like a tool that will update and upgrade the rights globally and to the maximum possible. And also some solution that can, on the adoption side, we want to approach communities that can have, a horizontal impact. A concrete example is we want to incorporate these licenses in our next open data editor. That will be like a no-code tool to publish data sets. And so by incorporating this set of licenses in something that we hope will be like a widely adopted digital solution to publish data and making it the default, we hope to combine an optimal legal tool with a very easy one-click approach to getting the adoption growing as much as possible. So yeah, that's what we are going to do. Community, a lot of workshops dedicated to UX and dedicated to reducing the technical frictions to incorporate these licenses, and a lot of talking and convincing to organizations that can be like our partners in testing this approach to start first test that there's no frictions in the way that this is going to be applied, and second that it is an appealing solution. If a credible organizations adopt it, it will be hopefully an appealing solution for people to start adopting a more strategic approach in sharing basically sharing in their own terms, but not stopping to share because they lack the vehicle to share in an efficient way.
Thank you so much, Renata. And with this, we close the interventions from the 4 speakers. And looking at the time, I think that I will open up the floor to questions, and I also have some questions myself, but let's see how interested you are in this topic. 1 and 2, 3, okay.
Thank you. First of all, thank you for the presentations, very interesting. I'm very interested on open research data that are under the scope of application of the Open Data Directive from 2019. Also considering that European institutions are strongly promoting the openness of research data. So I was wondering if your proposal also applies for research data, because you mentioned the asymmetry of power between providers and users, and if you consider the scientific research sector, I think it's even more relevant with the publicly funded research, so I was curious about that.
Do you want to ask this question to someone in particular?
Sorry, I was looking at the proposal of Yaniv and Melanie. Sorry, I didn't specify it.
Okay.
Melanie, if you don't mind, would you address that? Because you talked about the licensing schemes and I was talking about data trust. Or?
Yes, thank you very much for the question. It's easy because I'm an academic, so I'm part of this research community, and the same challenges and power relations apply to research data. Also, the same challenges for the global south. And I wanted to mention another initiative we are actually partnering with, which is called usage rights. It's also a set of licenses, and the focus is the research community. And there is this very similar to the privacy pledge, which we actually borrowed from European project Decode, and it was produced by partners at Politecnico di Torino. So usage rights have this clause of ecological pledge, which I cited at the beginning of my presentation, because there is this conscience by the research community. So that the research which is developed from this data should not be used in a way which would be harmful for the environment. So this is a commitment. It could be compared to data which would not be, or products which would not be tested on animals, for instance. Does that answer your question, or would you like to reply, contribute something?
And I guess next question there.
Hi. Okay, hi. Thanks for the very interesting presentation. So I think one of the problems with the data commons, at least as I see it, is that it's stuck a bit in a conundrum, because we know the problem of externalities with individuals. I give away my data, and that uncovers information about others. And I think this can also transfer at the group level if we have commons. So there is no reason why we cannot have a group of privileged people who are unlikely to suffer harm, who give away their data willingly, but that imposes externalities on others. So either you regulate the composition of the commons and what they can do with their data, but that kind of betrays the whole self-governance bottom-up rationale, or you leave it free, but then you face the issue of intergroup externalities. And I was wondering what you think about that and how you would go about tackling it. Thank you.
Was it specifically for the proposal, I guess? This is for the proposal on the data trusts, or in general? Is the question in general? I think you have to define a little bit more when you say free, as in open to anyone, because I don't think that's, at least our understanding here of data commons is not this, right? So there is definitely some accountability when it comes to how you use this resource, and I definitely wouldn't go on the like first hypothetical that you presented. I don't think that there is such a like specimen that you're describing, and to use your terminology, yeah, like zero externalities. I don't think that's the case to look up to or aspire to take example from.
But like, the people choose how they form a community, right? There are not any rules. They're free to give away their data because they can consent. So how do we preclude the possibility of externality? I don't know. Maybe we can talk about it later.
Yeah, I have a lot of doubts with the framing of this question. Actually, free to with consent to give all the data away. Yeah, that I have more doubts on the terminology.
Alexandra,
Yes.
can you hear me?
Yes.
Great. So to answer very quickly, I was trying to raise the hand. To answer very, very quickly, this is precisely what the consultation wants to address. I get your point. I understand your point. I think about, a very enthusiastic environmentalist group in my country, Guatemala, gathering specific data around mining companies. The environmental group is not aware of, the side effects of sharing that data, the side effects that might have in the communities living there. Quick on top of my head example. That's precisely what we want to do with the consultation, because this is a contractual instrument. What we want is to look at all the worst case scenarios or more complex case scenarios and try to find ways out. And of course, I think that having a collection of cases, very complicated cases with questions like this will help us to discourage when you have a very complex situation like that, this might not be the tool, but that there are like very complicated cases shouldn't discourage everyone from adopting a solution that might enable richer commons in critical issues for the critical data sets, for example. So in brief, this is precisely the kind of questions that we want at our consultation, and we want to listen to the communities on possible solutions and how to address them.
And also briefly to that point, so if your point is how to address the fact that many data subjects give away their data with this privacy resignation or paradox, that's exactly why, at least in this kind of contractual schemes plus data trust, we suggested to have this privacy pledge, which is a by default contractual clause that comes with by default, and according to which any providers needs to comply with the highest standard of privacy laws, and we referred to the GDPR, including the right to be forgotten, the right to withdraw consent at any time, and of course with privacy resignation, no one potentially will ask the right to be forgotten, but at least combined with data trust that are more concerned theoretically with knowledge and enforceability issues, they would ensure that the privacy pledge is respected. So I guess and hope this is the kind of concerns we also wanted to address with this combination of privacy pledge contract and data trust.
Hi, thank you for your presentations. I had a question for Yaniv and Melanie. I wanted to hear more about where does monetization fit in your framework? There was some gestures towards making sure there's like a fair distribution of value from these, from the data economy. And so I guess that's something I'm curious about. Would these frameworks be a way to also create monetization in some ways? Because that's, I guess, a question that then opens into a broader question to me about the sort of, are we assuming openness to be a good thing in like a self-evident way? Because to me, when we're talking about opening up like these big data sets like Flickr or these large public data sets, the kind of innovation and the kind of business models to which these will always be the resource is, I think, surveillance capitalism or things like generative AI, these extractive sorts of business models. So I think there's a more pointed question about monetization and then like a deeper question about like who is this data ultimately useful for, or what kind of use is it useful for, and are those uses something we should mount broader critiques towards?
Thank you very much. Melanie, I briefly answer and then give you the floor. I wanted to say, yes, indeed, the contractual framework suggested can combine compulsory, such as the privacy pledge, and optional element instead of full openness. There may be some restrictions, including for the types of uses, for instance, whether it's more ethical, depending on the values of the communities, or whether it's also for free or at charge for monetization purposes. And this is also based on the new open data definition that is subject to new definition, because, of course, we see that instead of full openness, there are now different ways of giving access to data. And therefore, the contractual scheme suggested different level of openness. And here comes, if you don't mind, Melanie, your suggestion, because you worked on this kind of level of openness.
Yes, thank you very much. Indeed, the idea is comparable to the non-commercial clause of the Creative Commons licenses, and it goes a bit further because it involves the data trust, so as collective management organizations at the level of communities, and who will have the opportunity to decide to authorize some usages or some communities for free, and for some other collection of fee, which will be subjected to collective governance, because the idea is that this money is not individual royalty in a way that it would compensate for the use of one personal data. That's not the idea. The idea would be collective use for the sustainability of the commons and of the communities. So collective governance.
And just to add on that, actually, again, back to the inspiration of collective management organizations from copyright, one important element is that in copyright, they set up also the price. And if we talk now about the economic value of data, because you were very rightly pointing out the social value of data, which is important as well, and which could be addressed via communities as well, if they define different values and not only economic. But if we stick to economic value and the monetization, data trust, data intermediaries could have also the tasks and the knowledge to fix a price of the usage data, because it's not that easy. And depending on the sensitiveness, on the type of users and the number of data, the price can be very different. And I'm sure intermediaries learning also from a copyright management organization could be helpful in setting the price.
Thank you all for your very nice, interesting panel. I hope you can allow me 2 very brief questions. If not, then just cut me. So the first one is, so one of the characteristics of an open commons is that the resource has to be non-excludable in principle. So
can you repeat that?
Yeah, the resource has to be non-excludable.
Yeah.
So in that sense, that's one of the essence of an open commons. So I was wondering whether would it be possible for you to think of a mechanism to get rid of consent. As consent is a mechanism to exclude, right, access to data. So can we get rid of consent as the source of excludability to create open commons? And if so, for which purposes? Would be there like a paradigm of, okay, are we going to use data without consent for certain purposes or not? And my second question would be, I'm picking up on the idea of data as relational. So data also comes with heavy environmental harms by just its use, storage, and so on and so forth. Do you envisage a way to, instead of opening more, just closing, just in light of the environmental harms that arise from collecting more and more data? Those two questions, I hope they make sense, otherwise I'll be happy to explain further.
Maybe I could just respond briefly. I think one of the things that an orientation towards, a critical orientation towards a data commons allows us to do is to think outside this binary of open versus closed. And I think what's also emerging from legal scholarship on data commons is that data in itself, perhaps we can think of it as dynamically classified as being both, in some cases, a common property resource, in some cases, a club resource, in some cases, a private good, depending on what that characterization of data is and what domain it exists, etc. And so if we then move away from this binary of open versus closed and we think more ecosystemically about the ways in which data is generated, the infrastructures necessary for its generation and its use, and the actors who control many, if not most, of these infrastructures, then the turning point is not really should we close certain data because it's too sensitive. It has too much, for example, like personally identifiable information, so close it, don't allow it to be accessed at all. Rather, it turns more on these infrastructures. Like, can we then intervene from a legal perspective at the level of the infrastructures and not at the level of opening or closing data? And one way forward in this regard, albeit perhaps subject to some changes, is the EU's approach on regulating gatekeepers, for instance, on recognizing that there are certain actors in the digital ecosystem that are exercising certain kinds of infrastructural control over value extraction from data. And maybe then to intervene at the level of these actors rather than to intervene at the level of access to or prohibiting access to data is, I think, how I would frame this differently. On consent, maybe Yaniv, you have something to add here.
Yes, no, I think consent is exactly via contractual consenting contractually with this kind of contractual scheme. You define the level of openness and you define the restrictiveness versus openness. So that's for the consent. And for instance, in our contract and many of them, they also make that that it is subject to privacy exceptions. So of course, I guess that's also what you mentioned or you pointed out. If there are exceptions, for instance, for research purposes, statistical or whichever exception, that would not be, of course, captured by the contractual commitment, the consent, because you cannot consent to exceptions that are provided under privacy laws.
I will abuse my role and ask at least one question. I had at least 4, but I will ask one, and I will ask it to Ramya specifically. Because you mentioned, in general, like the EU normative framework. I wanted to get your insight or prediction maybe on how do you see the role of the law, at least on an EU level, going forward with, let's say, imagining such type of licenses or, imagining kind of the future of open data commons.
Yeah, I was kind of reflecting a little bit on this also when I think about the role of like a top-down law or public law, if we think of it that way in the European sense. And I think there's 2 aspects. I think one is like what I was mentioning before, to recognize that data doesn't just exist out there on its own. Growing scholarship from critical data studies in STS shows us that data is not naturally occurring, but it is the product of processes of power, and there are certain constellations of actors who exercise that power. And that second, the kinds of value that get extracted out of data are also determined by the kinds of infrastructural control over data, which again then takes us back to who are these actors that own or control these infrastructures. And so I definitely think one role of the law, of public law in particular, is to intervene at this level, is to intervene through, for instance, competition law, to understand the kinds of the infrastructural dynamics of power concentrations in the emerging data economy, and to try and democratize that in certain ways, because it's no longer binary control. It's no longer either state control over data and data infrastructures, nor is it pure private sector control. But there are new emerging constellations between these actors. And I think the public law needs to be reimagined and needs to intervene at that level. And I think the second is, again, if we go back to that ecosystemic perspective, the legal kind of infrastructures for digital data, the use of data, or even if we kind of come up with these private law instruments like licenses to manage different kinds of claims or legal interests in data, these licenses need to coexist in an ecosystem that has data protection law, for instance, that has copyright law, that has all of these other laws. And so these licenses, of course, need to not completely ignore the background laws within which they exist, and they need to ensure that there is compliance with those other kind of thematically specific laws. So, for instance, I don't think that these kinds of, I don't think this Open Data Commons license, for instance, should mean that if you use the license as a data processor or as a data user, you don't have to show a legitimate interest for processing personal data if the data set that you're trying to use has personal data. They need to work in tandem with these other background legal frameworks that exist. And so I think there's another role of the law to play in kind of figuring out how to make private legal instruments like licenses work with public legal frameworks. Yeah.
Thank you so much. And with this, I think we have to close because more people are starting coming in for the next panel. Thank you all so much. Thank you to the speakers here and online.